Men cannot be raped. Men cannot be raped. It doesn't happen. It doesn't happen. It doesn't happen.
Hello, I'm lawyer Kyrie. May I know how can I help you today?
I I was forced sexually by a woman.
Oh, I'm so sorry to hear that. Thank you for having the courage to speak up. Do you feel ready to report it?
Yes, but I read somewhere that the law only recognizes women as victims.
Yeah, you are correct in a narrow sense. For Malaysian law, rape is defined under Section 375 of the Penal Code as an unlawful sexual intercourse between a man and a woman without the woman's consent and against her will. The Penal Code explains that there must be penetration to constitute sexual intercourse under the definition of rape. In Nasrul Anwar bin Abdul Samad against public prosecutor, it was held that the penetration in question must be a penal penetration to satisfy the offence of rape. The accused's conviction and sentence were squashed as the complainant was unable to prove whether there was penile penetration during the intercourse. Similarly, in Bunya Anak Jalok against public prosecutor, the accused cannot be charged with rape even though he took his semen-stained fingers after ejaculation and fingered the underage victim's vagina, causing her to become pregnant and give birth to a child, as there was no penetration with penis. Therefore, there was no rape. It is evident that rape is a gender-centric crime in Malaysia, with the implication that only men may be the perpetrator and women are the victims if we were to interpret the literal meaning of 375. Although rape laws are put in place to punish the perpetrators and protect the welfare of women who are typically more vulnerable, in reality, men can be victims of rape as well. However, the current laws does not recognize such things, which leads to justice unserved. Yusof Chain CJ in Sukma Darmawan Samitat Makjar against Ketua Pengarah Penjara Malaysia and Anor implied that male victims may file a charge against their perpetrators with the offence of gross indecency under Section 377D, as the perpetrator and victim under the wording of this section are said to include both genders. Having said that, this offence is unable to serve justice to the male victims due to its light sentence imposed on the perpetrators as compared to Section 375, where the male perpetrator who has committed rape would be subjected to heavier sanctions. Case law shows the court's attitude to such flaws in Malaysia's legal system. For instance, Awang Amarda Jaya Awang Mahmud JC in Suharman bin Muhammad Noor Ismail against public prosecutor and another appeal recognizes that other than women, men can be victims of sexual offences as well, such as under Section 377A. Robert CJ in PP against Imran Nasil has warned against the danger of convicting the accused in rape offences based on uncorroborated evidence while equally mentioning its applicability in sodomy cases. This can be inferred that although men are not seen as victims under the offence of rape, the courts, however, has attached great importance to the severity of the sexual offences committed against them.
I'm really sorry you are dealing with this. In England and Wales, the achievements of gender neutrality in sexual offences law have been advanced through the Sexual Offences Act 2003 and subsequent judicial interpretation. The Sexual Offences Act 2003 established comprehensive gender-neutral provisions. Section 1 defines rape as non-consensual penile penetrations of the vagina, anus, of mouth with being able to be either male or female. Sections 2 and 3 provide additional protections through assault by penetrations and sexual assaults, creating a framework protecting all individuals regardless of gender. The foundations was established by the Criminal Justice and Public Order Act 1994, which expanded rape's definitions to include penile penetrations of both vagina and anus, formally recognizing male victim for the first time in English legal history. These legislative reforms represented a fundamental shift from centuries of gender-restrictive rape law. Its practical significance was demonstrated in Iron Ritual, the first successful prosecutions for male rapes, establishing that male provision could achieve meaningful conviction. Anus Women on Survivor, a male victim support organizations, observed that the signal it sent out to men is that this is now being taken seriously and that the power that be are prepared to take it seriously. The definitive judicial statement on gender equality emerged in I. Milbury. The Court of Appeal per Wolf CJ affirmed that the same guideline should apply in principle to male and female rape, with factors relevant to only one gender taken into account on a case-by-case basis. These confirm that sexual violence inflicts equivalent harm regardless of gender victims and therefore warrants equivalent legal response. The courts rejected any gender-based hierarchy in victim status. The Court of Appeal further refines this equality principle in R. Ismail. This case addressed whether different forms of sexual assault warranted differentially legal treatments. Law CJ confirms the fact that this was oral rape doesn't mean that it is any less serious than vaginal or anal rape. While acknowledging no pregnancy risk in oral rape, the court highlighted sexual transmitted disease dangers, particularly when no protective actions was taken. I hope this information helped you well.
Welcome to Taylor's News. Today we have invited lawyer Kylie to discuss the comparison of law of rape between England and Wales and Malaysian jurisdiction. While both jurisdictions criminalize rape, the scope, evidentiary threshold, and structural protection reflect differing priorities in legal interpretation and institutional attitudes towards gender, consent, and justice. Under English law, rape is narrowly defined in Section 1 of the Sexual Offences Act 2003 as non-consensual penile penetration of the vagina, anus, or mouth. However, this statutory limitation is offset by Section 2 and 3, which criminalize assault by penetration and sexual assault, thus broadening the legal protection beyond the conventional parameters of rape. Collectively, these provisions ensure that any involuntary sexual penetration, whether by object, finger, or body part, is treated with equivalent severity, even if classified under a different offense. The key and analytical point is that English law differentiates offences by act type but equalize them in terms of legal seriousness, especially where harm is equivalent. Assault by penetration carries the maximum penalty as rape, life imprisonment, evidencing an intent to focus on harm, autonomy, and consent, rather than the instrumentality of the act. In contrast, the Malaysian Penal Code defines rape more rigidly, requiring penile vaginal penetration by a man against a woman without consent. This definition is both gender-exclusive and act-specific, excluding other forms of sexual violence such as anal or oral rape, object penetration, or male victimization from the legal scope of rape. These acts may fall under lesser offences such as Section 377CA or 377D, but they both lack the label and penal priority of rape. The legal consequences is a hierarchy of victimization. Similar act can result in vastly different charges, despite comparable levels of trauma and violation. The Malaysian framework thus reflects a categorical act-based model, privileging definitional precision over contextual harm. A major divergence lies in how each system treats consent. English law, through Section 74 of the SOA 2003, provides a statutory definition of consent as agreement by choice with the freedom and capacity to make the choice. This is complemented by Section 75 and 76, which create evidential and conclusive presumption of non-consent in cases involving coercion, unconsciousness, or deception. This evidentiary structure does two things. It acknowledges asymmetries of power and capacity within sexual relations and creates a burden-shifting mechanism, allowing the prosecution to focus on the circumstances of the act, not solely on the victim's resistance. Malaysian law lacks a codified definition of consent within Section 375 and has no statutory presumptions. Consent is interpreted judicially, often with residual reliance on corroborative evidence and physical injury as indicators of non-consent. For example, in Pimpit against Imran Nazil, the absence of physical injury was used to undermine the complainant's credibility, reinforcing the notion that force or visible resistance is necessary to establish rape. Another core difference lies in the interpretation of penetration and how courts operationalize statutory elements. In English law,
R against huge and R against slight established early that even slight penetration is sufficient. This was reiterated post-2003 with courts maintaining a low threshold for proving the actor's risk, ensuring that technicalities do not obstruct conviction, where other elements such as consent, identity, and etc. are proven.
Malaysian courts have followed a similar principle of penetration, however only slightly satisfies the actor's risk. Yet, because rape requires penile vaginal penetration, courts are frequently forced to exclude or downgrade cases where penetrations occurred via objects or fingers as seen in Bunya Anak Jagung against PP.
The analysis reveals the tension that even where harm, trauma, and non-consent are evident, the legal classification fails to reflect the severity of the violation. This leads to penal inconsistency and undermines the symbolic function of rape law in naming the condemning particular types of sexual offences. In English law, although rape is limited to penal penetration, male victims are protected under Section 2 and Section 4 of the Sexual Offences Act, which carry equivalent penalties and legal weight.
In contrast, Malaysian law excludes male victims from the legal definition of rape. Their experiences fall under lesser offences such as Section 377D or Section 354, which carries lighter penalties and receive less societal and legal recognition.
These reflect the gender legal framework in which sexual violence is treated as a violation of a woman's honor rather than bodily autonomy, resulting in certain harm being unrecognized and certain victims effectively rendered invisible. Thank you, Lawyer Khalil. We will now pass the floor to our guest lecturers, Professor Dorcas and Professor Christine, to give their views on whether the law of rape in Malaysia for male requires a change.
Thank you for having us here today. Rape in Malaysia is currently a gender-specific crime when act is committed by a man against a woman. Push Padiraja emphasizes how Section 375 of Penal Code is insufficient to address non-penal penetrative acts or female-perpetrated sexual violence, and it does not provide adequate protection for male victims. The offence under the current legislation is limited to penile vaginal penetration, which fails to recognise that rape affects both female and male equally, and should be reformed to make it possible for a criminal, be it a female or male, to be charged for male rape. By extending the definition of rape in the provision of 375 of Penal Code to include penetration of mouth and anus, such as in England and Wales, it guarantees equal protection for all victims irrespective of the type of assault. To do so, it is necessary to review that Section 375 of Penal Code should reflect gender equality and align with constitutional and international human rights standards to ensure inclusivity. Article 8 Clause 1 of Federal Constitution, which ensures equality before the law, and Article 8 Clause 2 of Federal Constitution, which forbids discrimination based on gender, are incompatible with the current Section 375 of Penal Code. Therefore, the scope of Section 375 of Penal Code should be extended to allow men to be a victim of rape for criminal justice and constitutional compliance. As seen in Suharman bin Muhammad Noor Ismail and Public Prosecutor at UMNO, the High Court ruled that although rape is a crime against women, men can also be victims of sexual offences. Thus, any gender-specific terms in Section 375 Penal Code should be replaced by the words of any person.
In light of the proposed amendments to Section 375 of the Penal Code, it is suggested that Sections 377A, 377B, and 377C, which involve carnal intercourse against the order of nature, should be repealed. Drawn from the Indian Penal Code of 1860 and imposed under British colonial rule, the phrase "against the order of nature" is a colonial relic which reinforces negative male rape stereotypes. It is an outdated school of thought which has no place in today's society where sexual assault cases against men are on a rampant rise. The law needs to reflect the severity of the offences, and by separating the offences into different categories such as rape and carnal intercourse against the order of nature, it gives the negative impression that a particular crime is given less significance compared with the others. There are no justifiable reasons why a man should not be protected in the same manner as a woman is protected, especially when it relates to an abuse of our bodily anatomy. Additionally, despite the apparent neutrality found in the wording of the provisions,
they are actually biased and discriminatory in nature as they operate without the element of consent. Unlike rape under Section 375, the sodomy laws criminalize carnal intercourse with or without consent. Therefore, even consensual sex between adults would be considered a crime. This makes them highly susceptible to exploitation for political purposes rather than being used for what it was intended, which is to protect innocent victims, including men, from sexual assault and rape. The exploitation of said provisions was evident in the case of Datuk Seri Anwar Ibrahim, which led to the accusation that this law exists mainly as an instrument of political persecution. There have been a total of 7 charges from 1928 to the present, and 4 out of those 7 charges are connected to Anwar. If nothing is done to overcome this issue, then the police and government will have arbitrary powers to use against their political opponents. This will understate the initial intention of these provisions, which is to protect innocent victims, including men, from sexual assault and rape. By implementing gender-neutral terms such as persons and widening the definition of rape to include vaginal, oral and anal penetration under Section 375, we can extend the scope of legal protection to male victims too, thereby negating the necessity of Sections 377A to Section 377C. Multiple NGOs and human rights associations have advocated for the need to repeal Section 377A to C in the Malaysian Penal Code. These include Amnesty International, the Malaysian Bar Council, and even the ICJ. Justice Elizabeth Evert, the Commissioner of the ICJ, urged Malaysia to repeal Section 377B, as such sodomy charges are not recognizable criminal offences under international human rights law and standards. Reference can be made to our neighbouring country, Singapore, who have already repealed a similar provision in October 2007. Advanced Tertiary College Senior Law Lecturer Reza Zakaria called these sodomy laws archaic as it perpetuates the view that the man is always the sexual aggressor and the woman is always the victim. This leaves male victims in a predicament as when they lodge a report, cases will often be classified under different provisions instead of rape, thereby reinforcing the legal gap between men and women. Ergo, raising awareness among society is crucial to break the stigma and misconceptions surrounding the issue. Awareness programs and activities help to educate the public to know that criminal offences should not be defined by who they happen to, nor be gender specific, but by the violation itself. Sexual assault, especially, is not about gender, but rather the power of the perpetrator to overpower their victims. Nationwide education campaigns should be implemented through social media, TV advertisements, and schools. Nothing Gentle in the Shadows by Joshua in Barrage is a leading example of involving male survivors in advocacy efforts through a documentary film in order to raise public awareness about the issue.
In conclusion, while both English and Malaysian law criminalize rape, the underlying logic and legal architecture differ substantially. English law adopts a harm-based and inclusive model supported by statutory presumptions, definition clarity, and an evidential structure that prioritize victim protections and doctrinal coherence. Malaysian law, by contrast, is formalist, gender-specific, and structurally limited, often prioritizing definitions over impact, and offering incomplete legal recognitions of the spectrums of sexual violence.